Ma'am, kindly confirm the position. Is it visible, ma'am?
Yes, sir, it is visible.
Okay, okay.
Good evening to all the participants present here. We would request you to please open the camera so we will begin with the proceedings of the final round of the competition.
Can you hear me?
Yes, sir, you are audible. DL183, speaker 2, please open your camera so we can proceed further. Good evening to all. I'm Manya, one of the OC members of the Dream Law, and I have immense pleasure to host the finals today. I would like to congratulate all the participants who have qualified for the finals of the Samar Kumar Basu National Moot Court Competition 2023, organized by City Law College, Lucknow, in collaboration with Dream Law and co-sponsored by SKB and Associates, Kolkata. I would like to thank our esteemed judges for the finals. Their valuable insights will undoubtedly nurture the talents of our participants. Now, I would like to present the stage to Ms. Shazia Khan to introduce the judges to the finalists and to the team.
Thank you so much, Manya. Greetings, judges. Today, we have the eminent personality, Honorable Mr. Justice Arindam Lodh with us. His lordship practiced before the Agratala bench of the Honorable Guwahati High Court till the formation of the High Court of Tirupura in the year 2013. And after that, under the High Court of Tirupura Agratala till his lordship's elevation. His lordship has worked as CGC and railway advocate for Agartala bench of the Guwahati High Court. We are also glad to have with us Mr. Milan Mukherjee, who is a senior advocate. He is one of the finest criminal lawyers in Eastern India, primarily practicing in the High Court of Calcutta. He is a part of almost all the high-profile cases of the West Bengal and its adjoining states. During these 40 years of practice, Mr. Mukherjee has earned immense repute in his profession and most popular personality inside the court of his intelligent court crafts. We also have with us Mr. Mangaljit Mukherjee with us, who is currently practicing in the Supreme Court of India. He has 16 years of practice under his belt, and prior to that, used to practice in the Kolkata High Court. I would like to thank all the judges for marking their gracious presence in this Moot Court competition. Over to you, Manya.
Thank you, Ms. Shazia. Now I would be presenting the rules of the round. So each team would be getting 40 minutes to argue, which will include both rejoiner and surjoiner time with the bench, with the prior permission of the bench. And no speakers can speak.
Manya.
Yes, sir.
Just wait for a second. Justice Lodh is on his way. So I'm just constantly trying to contact you, but I couldn't contact Justice Lodh. Just give us 1 minute time. He'll be joining in a GP. Just wait for a minute.
I'm so sorry.
Anya, you can start.
Thank you, sir. So, a very good evening to all. I'm Manya, one of the OC members, and I feel immense pleasure to host the finals today. I would like to congratulate to all the participants who have qualified for the final rounds of the Samar Kumar Basu National Moot Court Competition 2023, organized by City Law College in collaboration with Dream Law and co-sponsored by SKB and Associates, Kolkata. I would like to thank our esteemed judges for the finals. Their valuable insights will undoubtedly nurture the talents of our participants. Now, I would like to present the stage to Ms. Shazia Khan to introduce the judges to the finalist teams.
Thank you, Manya. Greetings to all the judges. Today we have the eminent personality, Honorable Mr. Justice Arindam Low with us. His lordship practiced before the Agratala bench of the Honorable Guwahati High Court till the formation of the High Court of Tirupura in the year 2030. And after that, under the High Court of Tirupura Agratala till his lordship's elevation. His lordship has worked as CGC and railway advocate for Agratala bench of the Guwahati High Court. We're also glad to have with us Mr. Milan Mukherjee, who is actually a senior advocate and also one of the finest criminal lawyers in Eastern India, primarily practicing in the High Court of Calcutta. He is a part of almost all the high-profile cases of West Bengal and its adjoining states. During these 40 years of practice, Mr. Mukherjee has earned immense repute in his profession and has the most popular personality inside the court for his intelligent court crafts. We also have with us Mr. Mangalit Mukherjee, who is currently practicing in the Supreme Court of India. He has 16 years of practice in the Supreme Court under his belt, and prior to that, used to practice in the Calcutta High Court. I would like to thank all of the judges for marking their gracious presence in this moot court competition. Thank you, Manya.
Thank you, Ms. Shazia. Now, I would like to present the rules of the round to all the finalist teams. Each team would be getting 40 minutes to argue, which includes both rejoiner and surjoiner time with the prior permission of the bench. And no speaker can speak for more than 25 minutes, subjected to a maximum time limit of 40 minutes. With this, we wish both the teams all the best for the competition and may the best team win. Thank you.
Permission to begin, Your Lordships.
Yes, yes. You may begin.
Much obliged, Your Lordship. Warm greetings to the bench. This is the council appearing.
Most welcome to all the participants.
Not Milan Mukherjee.
My respect to.
Thank you, Justice. Thank you, Justice. Thank you.
Actually,
We had good times together. Thank you.
How are you?
Better, much better. You look younger. Thank you. Okay, let's start.
Yes. Yes, sir, we must start.
Warm greetings to the bench. This is the council appearing on behalf of the appellant, Mr. Sanjay, in the case of Mr. Sanjay Behta versus Mrs. Divya Seth. Your Lordship, the council seeks the permission to address the bench collectively as Your Lordships. Much obliged, Your Lordship. Your Lordship, would Your Lordships appreciate a brief perusal of the facts of the case in hand?
That would be helpful.
Much obliged, Your Lordship. So, Your Lordship, the facts of the case, this present case are, Mr. Sanjay Behta, the appellant, is an Indian lawyer who is married to another lawyer, Mrs. Divya Seth, who is the respondent. In 2009, the couple was blessed with a biological boy, Anubhav. On 1st of August 2019, upon his parents' insistence, Anubhav opened up. The respondent post this concluded that Anubhav was a woman trapped in a man's body. On 10th of August 2019, the appellant took Anubhav to a psychologist, Dr. Aditya Srivastava, who concluded that Anubhav was suffering from gender dysphoria. Anubhav started watching documentaries and was influenced to undergo gender reassignment surgery. On 1st of September, Your Lordships, the couple had a fight. Post this, the respondent, along with Anubhav, left her matrimonial home. On 20 January 2020, the respondent took Anubhav to Delhi for gender reassignment surgery. The surgery was successful and Anubhav was now a girl. The appellant filed a petition for divorce on 6th of February 2020 before the Family Court of Lucknow. The Family Court granted divorce to the appellant on the ground of cruelty and declared the appellant as the guardian of Anubhav. The respondent further filed an appeal before the Honorable High Court of Allahabad, Your Lordships. The High Court set aside the judgment and decree passed by the Family Court, and the respondent was declared as the legal guardian of Anubhav. Finally, Your Lordships, agreed by this judgment of the Allahabad High Court, the appellant has filed a special leave petition before this Honorable Supreme Court on 18th April 2022. The matter is now for final hearings, Your Lordship. Your Lordships, in the present matter, Council will be dealing with issues 1 and issues 3 in 23 minutes. And my co-counsel will be dealing with issue 2, Lordship, while we reserve 3 minutes for rebuttals, Your Lordship. If Your Lordships are satisfied with the facts of the case in hand, Council seeks permission to move on to the issues in hand, Your Lordship.
Yes, sir.
Much
Move
obliged.
on.
Much obliged. Your Lordship, the first issue in hand in the present case is whether a child of tender age of 11 can take decision upon his own welfare, especially when such decision involves complex issues of gender identity, Your Lordships. Your Lordships, prior to the commission of submissions under issue 1, the Council would like to mention that Section 15 subclause D of the Transgender Persons Act 2019 mandates the government to bring out health manual related to sex reassignment surgery. Your Lordships, with the due permission of the bench and for the convenience of the court, the same can be screenshot by my researcher, Your Lordship. It will be presented, Your Lordships, for the convenience of the bench. With your due permission, Your Lordship.
Yes, yes.
Yes, yes, go ahead, go ahead.
Go ahead.
Much obliged, Your Lordship. It seems there is some glitch with screen sharing, Your Lordship. As soon as it is allowed, it will be presented for the court's convenience. Substantiating via orals, Your Lordship, Section 15 subclause D of the Transgender Persons Act mandates the government to bring out a health manual related to sex reassignment surgery, which is in accordance with the World Professional Association for Transgender Health, also known as the WPATH Guidelines version 8, Your Lordships. In compliance with the same, the Association for Transgender Health in India, that is the ATHI, was established, Your Lordships. Disappointingly, the updated Indian standards of care have not yet been devised by the authorities. However, the ATHI mandates that the standards of care version 8, that is, these WPATH guidelines, are to be duly followed in the country. These are the guidelines, Your Lordship, issued by WPATH in interest of transgender health. As upheld by the landmark judgment of NALSA, Your Lordships, citation being 2014 5 SEC 438. Article 51 of the Indian Constitution, when read along with Article 253, infers that the court in India would respect the rules of international law, especially when there is no inconsistency between the two and there is a void in domestic law. Thus, these guidelines issued by WPATH, Your Lordships, are deemed to be followed. Stating this, the Council will now move on to issue 1, Your Lordships. In reply to issue 1, the Council would like to most humbly present that no, a child of tender age of 11 years cannot take a decision upon his own welfare, especially regarding complex issues of gender identity, Your Lordship. The same will be dealt by the Council on 4 fronts. Firstly, gender identity is a complex issue. The argument that the children of such a tender age can process what they are experiencing is in itself not concrete. The burden of such an integral decision cannot be imposed on children, especially on 11-year-old children, your lordships. Indicated by the findings of various studies and as reiterated in the presented WPATH guidelines, we will now move on to page number 103 of the guidelines, your lordships. Hoping that the guidelines are clearly visible, it is mentioned in the guidelines, your lordships, that international human rights organizations have increasingly expressed their concerns that surgeries performed before a child can participate meaningfully in decision-making may endanger the child's human rights to autonomy, self-determination, and open future, your lordship. Further, numerous medical and intersex advocacy organizations, as well as several countries, have joined these international human rights groups in recommending the delay of surgery when it is medically feasible, your lordships. On the B side of the same page, it is mentioned that non-urgent surgical care for individuals with these variations is complex and often contested, particularly when an individual is an infant or a young child and cannot yet participate in the decision-making process, your lordships. Therefore, these guidelines thoroughly establish that gender reassignment surgery is linked to elevated rates of complex trauma, social stigma, and violence. Taking all this into consideration, your lordships, it is absolutely established that child of tender age cannot withstand all the mental agony and struggle, your lordships. The council has therefore proven that gender identity is a complex issue, and in the very case, introducing Anubhav to additional mental grievance of such a huge quantum will deteriorate his stability with grave repercussions, your lordships. Further, moving on, your lordships, in the case of Barun Chandra Thakur versus Master Bholu, citation being 2022 SEC Online SC 870. A division bench of this Honorable Supreme Court drew a line of difference between mental maturity and the ability to understand the consequence of an act. They stated that the ability to understand the consequence of the act lies in the intellectual knowledge, which is corresponding to the IQ, your lordships. But the extent of control of actions will depend on the level of their emotional competence. The court established if emotions are too intense and the child is unable to regulate them, then the intellectual insight or the knowledge will take the backseat, your lordships. In the present factual matrix, Anubhav didn't have many friends in school, your lordships, which is mentioned in the proposition on paragraph number 4, your lordships. On paragraph number 3 and 4, how Anubhav didn't have many friends in school. He was always made fun of by the boys and he was called gay. Thus, he was emotionally going through a lot, your lordships, owing to the bullying at school and further the friction in the relationship between the parents. Therefore, it is established that he was emotionally going through a lot. He was under an emotional turmoil. At this juncture, it becomes unthinkable of a child of such age to take a well-informed and analyzed decision. Thus, the lack of mental maturity of Anubhav is undoubtedly established. Moving on, your lordships, based on current evidences in transgender women and gender diverse people who are assigned male at birth, when considering the influence of medical treatment, the psychological burden of re-exposure to testosterone must also be considered. It has unforeseeable and unanticipated impact on the reproductive health of the individual. All in all, the enormous impact on the mental health and the associated risk with the procedure makes such a decision non-conducive for Anubhav to make, your lordships. Further, such a decision will also have a huge impact in the case of change of mind, your lordships. In this particular issue, finally, the council most reverently submits that Anubhav's decision was also influenced by various facts, your lordships, various factors. It is pertinent to note that the respondent in the present case, Mrs. Divya, implanted the idea that Anubhav was a woman trapped in a man's body. The same is mentioned on paragraph number 6 of the Moot proposition, your lordships. Influenced by this, he watched numerous documentaries and was affected significantly. by those wherein people had undergone the gender reassignment surgery. Only after being confused and influenced by all of this, he insisted on the surgery in the first place, Your Lordships. Now, in the present matter, the mature minor principle, which was adopted in Australian law in Marian's case, Your Lordship, that is Secretary, Department of Health and Community Service versus JWB and SMB. And it is a common, it says that it is a common law capacity assessment standard for Australian children's healthcare decisions. But the Australian courts are reluctant to allow children to make any healthcare decision not in the best interest of the child, Your Lordship. The council further highlights that in the Australian judgment of X versus Sydney Children's Hospital Network, it had underscored and were reluctant to allow children to make any healthcare decision which is not in the child's best interest. Despite wide acknowledgement that individual autonomy is fundamental and personal bodily integrity is paramount, courts did not allow autonomy to prevail over a child's best interest, Your Lordships. Therefore, the council is making the contention that sex reassignment surgery premature precisely proven that Anubhav, who is 11-year-old at the time of making the decision, was incapable to decide upon his own welfare and decide complex issues of gender identity. Therefore, the first issue stands resolved, Your Lordships. If Your Lordships have no questions regarding the issue, council seeks permission to move on to issue 3, Your Lordship.
I have a small query.
Much obliged, Your Lordship.
Right? Tell me one thing. Have you seen 15C of the Act of 19?
Indeed, yes, Your Lordship. 15C of the Act.
Yes. Now, both had an obligation, including Anubhav's father, to go for counseling, which has been provided under that subsection.
Indeed, yes, Your Lordship.
Yes, you have to understand one thing. We are on a question of whether changing the identity of a boy would tantamount to cruelty in a divorce proceedings. Right? So now the question is, when the law has been there, did any of you, did the father take any steps when the government provided for free counseling? What is the answer to that?
Much obliged, Your Lordship. Answering your question, it is mentioned on paragraph number 7 of the Moot proposition, Your Lordship, that Mr. Sanjay took
I want your answer. I don't want is the proposition. I want your answer it. Because the irony of it is you're reading out. You're not with passion, you're not doing the case. That's the issue. You have to say it from the heart. There's certain things when you're on a welfare of a child, you have to ascertain that the child is the aggrieved person. He is being torn between the father and the mother. So there has to be a little bit of passion on your part. Don't mind me saying that, but you are a future, maybe the Chief Justice of India. So you have to understand a little bit of passion. Go ahead.
Much obliged, Your Lordship. Apologies for that. What I would like to mention, state in the answer is, indeed, yes, it is the child's interest in the present case, and there is friction between the relationship of the parents, Your Lordship, and the child has been going through this. He is aware of what is going on around him, Your Lordships. However, when we take into consideration of his proposal to go through the surgery, it is tantamount on the parents to consider what is in the welfare of the child, Your Lordship.
That is what I'm trying to tell you.
When
it comes to the welfare, when it comes to did the father make any attempt to take him to a good psychiatrist or a psychologist? The consequences of an assignment surgery that being done, that was never done by the father also.
Much obliged. In answering to your question, Your Lordship, it was the father. It was the appellant, the father, Mr. Sanjay, in the present case, who took Anubhav to a psychologist, Dr. Aditya Srivastav.
Correct. That's a part of your pleadings.
Indeed, yes.
Yes. What are the consequences of that?
The consequences.
Why was not the mother taken?
The consequences of this, Your Lordship, it was proposed to the mother. The idea of the father was proposed to the mother that in the best interest of Anubhav, it is important for us to peruse his situation here. It is important for us to ensure that we are aware of what is going on in Anubhav's mind. The same was in the interest of the father, and he took him to a psychologist, Your Lordship.
Okay, I've understood. Next, go ahead.
Much obliged, Your Lordship. If there is no further question regarding to issue 1, Your Lordship, Council seeks permission to move on to issue 3.
Okay, go ahead. I ask the other judges, ask Justice Lodh, ask
Yes, yes.
Mr. Mukherjee.
Yes,
Go ahead then.
go ahead.
Indeed.
Issue number 3.
Much
Issue
obliged.
number 3, come.
Much obliged, Your Lordship. The Lordship's issue number 3 in the present cases, whether actions of Mr. Sanjay not supporting Anubhav in his decision to undergo the gender reassignment surgery can be termed as acting against the welfare of Anubhav. Here, Your Lordship, the Council would most respectfully submit that no, it cannot be termed as acting against the welfare of the child, Your Lordship. Mr. Sanjay's decisions, efforts, and actions have all been in conformity and in line with the intention of upholding the greater welfare of Anubhav, Your Lordship, who is 13-year-old now. The same will be justified on 4 fronts, Your Lordship. Firstly, the Council submits the paramount consideration in cases like this should be the welfare of the minor child, as defined by this Honorable Supreme Court in the Rajeshwari Chandrasekhar Ganesh versus the state of Tamil Nadu. This judgment, citation being 2022 SEC Online, SC 885. Welfare is an all-encompassing word, Your Lordship. This was mentioned on page 16, paragraph 89. In the instant factual matrix, Anubhav was diagnosed with gender dysphoria on 10th of August 2019 by one of India's best psychologists, Dr. Aditya Srivastav. Also, as defined under section Clause K of the Transgender Persons Act, Anubhav recognized and perceived as a transgender person. Now, Your Lordships, the respondent, as mentioned previously, quickly concluded that Anubhav was trapped. Anubhav was a woman who was trapped in a man's body. The same is mentioned on paragraph number 6 of the Moot proposition. She quickly concluded that he was a woman trapped in a man's body. Further, when Anubhav put forth the fact that he wishes to undergo the gender reassignment surgery in the first place, the respondent again quickly agreed to it. She did not give it sufficient thought, was hasty and impulsive in making her mind, disregarding considering various other vital alternatives which are available, which would have been in the best interest of Anubhav, Your Lordship. Her unwise submission to Anubhav's proposal is highly objectionable. Moving on, it was also held by the Supreme Court in the landmark case of Rohit Hamana Gowda versus State of Karnataka and others. Citation being 2022 Live Law SC 643. The court had explicitly held what is the wish or desire of the child is different and distinct from what would be in the best interest of the child. The question as to what would be in the best interest of the child is a matter that is to be decided by the court, considering all the relevant circumstances. In the instant case, Your Lordship, the appellant had the right desire to ensure that he did not jump to any unstudied or spur of the moment conclusions, Your Lordship. He was thoughtful, he had his patience, and this is supported by international domestic standards regarding the issue, and it was conducive with the best welfare of Anubhav as well. Now, in order to prove the same, the Council states that World Health Organization reports and the National Health Mission in India have clearly stated that the age of adolescence is around 10 to 19 years, which depends on case-to-case basis, Your Lordships. Now, the WPATH guidelines, which are issued in the best interests of welfare of transgender people, Your Lordships, have a separate subsection dealing with adolescent cases. The same will be applicable in the present matter, Your Lordship. To further establish these contentions, that the appellant's conduct was sufficiently backed by domestic law and international standards and guidelines, the WPATH guidelines will now be presented on the screen, Your Lordships, pointing out to how Mr. Sanjay in the case had acted in the best welfare of his child Anubhav. The same guidelines, with the due permission of the bench, will be presented screen shared right now, Your Lordships.
Mr. Counsel. Oh, okay.
Indeed, yes, Your Lordship.
After you finish, I'll talk to you.
Much obliged, Your Lordship. Notably and most importantly, Your Lordship, the guidelines do not introduce surgery as the ideal remedy, and they jot down numerous other alternative remedies to be considered for treatment of gender dysphoria. However, as per the guidelines, male to female patients, surgical procedures and the criteria which are included are as mentioned on page number 67. Yeah, here is page number 67. If you can zoom it a little bit for the convenience of the bench. Yes, indeed, yes. Your Lordships, it is clearly mentioned higher ages may be required for treatment with gender irreversibility, complexity, or both, with apologies, with greater irreversibility, complexity, or both. This approach allows for continued emotional maturation that would be required for the adolescent to fully consider and consent to increasingly complex treatments, Your Lordships. This is exactly what the appellant wished for Anubhav in the present case. The gravity and the complexity of the procedure had to be thoroughly realized and perused prior to initiation of the process, since the surgery once concluded is permanent and irreversible. Now moving on to page number 68 of the guidelines, Your Lordship. Page 68. It is specifically mentioned, given the complexity and irreversibility of these procedures, an assessment of the adolescent's ability to adhere to post-surgical care recommendations and to comprehend the long-term effects of these procedures on reproductive and sexual function is very crucial. The same points are mentioned on page number 26 of the written submissions of the appellants as well, Your Lordship. Therefore, Your Lordship, the appellant only wanted to appraise and rule out any other alternative, including puberty blockers, hormone therapy, etc., that could prove fruitful in Anubhav's case before consenting for the surgery, Your Lordship. Now, certain criteria regarding the surgery include capacity to make fully informed decision, age of majority in the country. Moving to page number 50 of the guidelines.
Is Speaker 1, whether this argument is necessary to substantiate the issues or it is related to the issues, relevant to the issues.
Much obliged, Your Lordship. Answering your question, these guidelines are in
the complexity we shall enter, whether this is the stage to enter into the complexity and the necessity and what will be the consequences. Because question is that whether the decision of Mrs. Dibashet is amounts to cruelty or towards her husband, or it is against the welfare of a child. So this is the question we must confine within this. So
much obliged, Your Lordship. The council is dealing with issue number 3, Your Lordship. Issue number 2 will be dealt by the co-counsel. Issue regarding cruelty will be dealt by the co-counsel. Issue number 3 is with regards to how Mr. Sanjay's acts were in the welfare of the child, Your Lordship.
yes,
The council,
whether to decide this issue, these arguments are necessary.
much obliged, Your Lordship.
Consequences.
I'm totally in agreement with Justice Loth. And another thing, the citations you are giving, how many of them relate to divorce matters?
A lot.
Because the welfare, because the irony of this act of 2019 doesn't have a definition of child.
Indeed, yes, Your Lordship. It is
So you have to
defined as
understand
justice.
it. Whatever citations you are giving are on the facts of those cases. As my Lord Justice Loth has rightly said, are they for the benefit of this proceedings before us?
Indeed, yes, Your Lordship. Answering your question.
How?
The case mentioned, the previous case mentioned was Rohit Thamanna Gowda versus State of Karnataka. This was a case which was by the father for the custody of his 9-year-old child in best interest.
That is what I'm saying. The welfare, there is a two difference here. The welfare of the child, as you know very well, you must be knowing, you are a good student nowadays. First thing is, the father is always the natural guardian, right?
Indeed, yes. As per section.
And but up to the age of 5, it normally should be with the mother. Why? The reason being what? There has to be a reason being a legislation. Now, what you are trying to impress upon us is that a welfare as defined under a different act is also applicable to the meaning of this word welfare in this act also. Both cannot be so same. That's my reading of the section and everything, subject to what you answer back.
Much obliged, your lordship. Answering to that particular question, as rightly pointed out, even the word welfare is not defined in the Hindu Minority and Guardianship Act.
Right, absolutely right. It is all judgment law.
Indeed, yes. Indeed, yes. It is.
That is what I'm trying to say. As Justice Loth has rightly said, what your citations, what does it aid with this present case? How does it fit into the present case?
Indeed, yes, your lordship. The case of Rajeshwari versus the state of Tamil Nadu, which was previously cited, is also a custody case, your lordship. It was a case wherein a father was fighting for the custody of his child. Now, in this case, the court upheld the welfare principle, which was mentioned, and they defined welfare to be an all-encompassing word. They mentioned that the criteria of holistic development of the child should be taken into consideration. There should be no impediment as to the development of the child, and it should be in the best interest, satisfying the further development of the child. This is how welfare was defined in that particular case, your lordship. Further, in the Rohit Thamanna case, which was cited, your lordship, this was also a custody case. This was a writ of habeas corpus, which was filed in the High Court, your lordship. Now, in this case, again, the court held that even though a child might wish for something to happen, it is for the court to consider what is in the best interest of the child. Only merely moving on with the desire or wish of the child is not a right approach. The what would be in the best interest and greater welfare of the child should be considered by the court by looking at the appropriate circumstances. Now, by presenting these guidelines, what the council is trying to prove is, your lordships, before the surgery is undertaken, there are a lot of procedures. Now, these procedures which are established by law are in the interest of transgender health. They have procedures like undergoing counseling, undergoing the valuation and certification by 2 psychiatrists. So all these have been mentioned so that the final stage, which is the last stage, the surgery can be prevented, because only by undertaking these procedures as well, the resolution of the problem of gender dysphoria can be undertaken, your lordship. Now, this was exactly what the appellant, that is the father, Mr. Sanjay, was considering. He did not want to be impulsive and directly go to the issue of undertaking the surgery. He wanted time. He wanted time to peruse what was going on with his son, Anubhav. He considered his greater welfare in the future. He understood the situation well, and he rightly suggested that there should be consultation undertaken of a psychologist in order to peruse what Anubhav is actually going through, and then the procedures might be undertaken. He was never against the surgery as well, your lordship. He just wanted to make sure that Anubhav is mature enough in order to handle the repercussions or handle the effects of the surgery, your lordship. He wanted Anubhav to give his informed decision before taking any irreversible step, your lordship. So he was acting in his greater welfare, and what these guidelines have rightly pointed out is there are all these steps before the final step of the surgery is undertaken. When these steps are followed, there is a high possibility that the resolution of the problem does not lead to the surgery, your lordship.
Right.
So undertaking welfare, best interests of the child were all that considered in that were undertaken by Mr. Sanjay in the case. Now, your lordships, as it is thoroughly proven that the appellant was taking diligent actions and upkeeping welfare in his mind, as also suggested by Dr. Aditya Srivastav, which are in harmony with these guidelines, your lordships. Further, moving on, your lordships, there was a report by the World Health Organization, your lordships, which was titled Sexual Health, Human Rights and Law. The same will be presented now, your lordships. Page number 34. Here it is clearly mentioned regarding the decision of the parents in the case of considering the welfare of the child. It is mentioned a major concern for intersex people is the so-called sex normalizing procedure, that is the surgery, which is often undertaken during infancy or childhood to alter their bodies, particularly the sexual organs, to make them conform with their identity. Such children may be subjected to medically unnecessary, often irreversible interventions that may have lifelong consequences, Your Lordship, on their physical and mental health, including the irreversible termination of these. Now, Your Lordships, medical procedures have justified in cases that these pose a health risk and are considered life-threatening. Such procedures are sometimes proposed on the basis of weak evidence without discussing and considering the alternative solutions. As mentioned, the surgery is sometimes proposed by the parents on the basis of weak evidence, Your Lordship. This is exactly what undertook in the present factual matrix, wherein the mother, Mrs. Divya Seth, was impulsive in making her decision without perusing all the other vital alternatives, Your Lordship. Sanctioning the surgery of the child would not be in the best interest of the child, Your Lordship. This is what the council is stating. Finally, the council is also pointing out that it is held in numerous judgments that the consent of the parent cannot be considered as the consent of the child. The father in the present case had believed that in the near future, Anubhav will become mature enough to take such decisions about his own life. In the Nalsar judgment, which will now be presented, Your Lordship, on page number 106, paragraph number 103, Your Lordship, it is mentioned that the transition from a man to woman is not an overnight process. It is a painfully long procedure that requires a lot of patience. A person must first undergo harmony therapy and, if possible, live as a member of the desired sex for a while. Moreover, to be eligible for the same, the person needs at least 2 psychiatrists to certify that he or she is mentally sound, and schizophrenia, depression, and transvestism have to be ruled out first. Now, Your Lordships, in the present case, it was the father who took Anubhav in his best interest for consultation to a psychologist, Your Lordship. As mentioned in the Nalsar judgment, it is for the clinicals, it is for the experts to certify that how the child can undergo the particular procedure, Your Lordship. Now, this was not considered by Mrs. Divya Seth, the mother. She was impulsive in deciding on behalf of his child, Your Lordship. So therefore, there is a violation of the procedure that is mentioned in this judgment as well, Your Lordship. Further, lastly, pointing out, there was a report, Your Lordships, which was by experts dated 11 to 2023, 11th of February. 105 gender reassignment surgeries were performed at the government hospital in Madurai, Your Lordship. In this report, what this report signifies is, Your Lordship, what is the present scenario? What is the on-ground scenario? There might be procedures which are on paper, but this research wants to point out, by taking into consideration the judgment and the guidelines, what is the on-ground scenario, Your Lordship. In this case, 105 people underwent the gender reassignment surgery. It is mentioned that the hormone treatment is given for a minimum period of 6 months, and it is ideally for a year. The mental stability of the person is also studied. And it is mentioned that the gender reassignment surgery is only performed on a person who is aged more than 18 years with their consent. It is clearly mentioned on the highlighted paragraph, Your Lordship, that only on individuals aged about 18 with their consent, this surgery is to be performed. So the doctors, experts have all been prescribing that in not undergoing the surgery in the initial stages and by undergoing all these procedures would be in the best interest of the child in order to rule out all other possibilities, Your Lordship. Therefore, the respondent's ill-judged, the respondent, that is the mother's irresponsible conduct, has led to abrupt repercussion to the completion of sex reassignment surgery of Anubhav by violating the guidelines, the Indian standards and criteria which were framed by WPATH, the Indian court in itself, and also prescribed code of conduct. The appellant, Mr. Sanjay, has sufficiently proven that the contention that his actions were in the interest of greater welfare of Anubhav. They are in harmony with his best welfare. Finally, concluding my arguments, Your Lordships, it is reiterated that the appellant, who is the father, recognized the rights of his child, your lordships. He was solely not consenting to the surgery at that particular time, your lordship, because they had to peruse through all the other alternatives and options available. They had to understand the situation, which requires time. The impulsive decision will not be in the welfare of the child, your lordship. Therefore, the father, Mr. Sanjay, the appellant in the present case, undertook all the actions which were in the best interest of Anubhav, your lordship, for ensuring his greater welfare, for ensuring that there is a holistic development of Anubhav, your lordship. If your lordships have any questions, or if
No. Thank you. Thank you.
Thank you.
much obliged, your lordship. If no further questions, counsel leaves the podium and requests his co-counsel to continue, your lordship, with your due permission.
Thank you.
Much obliged, your lordship. Much obliged.
Your lordships, am I both audible and visible?
Yes.
Much obliged, your lordships. Warm greetings to the honorable bench. This is Speaker 2, appearing as counsel on behalf of the appellants. The counsel seeks permission to address the bench collectively as your lordships.
Yes, yes.
Yes.
Much obliged, your lordships. Your lordships, if I may continue from where my co-counsel left, the issue that I will be addressing, your lordships, is that of whether the actions of Mrs. Divya Sith supporting and taking Anubhav for his gender reassignment surgery without the consent of the father, Mr. Sanjay, amount to cruelty and acting against the welfare of child. Your lordships, certainly the two huge limbs of arguments that the council will argue today will be amounting to cruelty and the welfare of child here, your lordships. To begin her argument, she would like to rely on the first limb of argument, where she'd state that right to parental consent and decision-making was violated. The appellant challenges the High Court's order that granted custody and guardianship of his minor child to the respondent, who is not the sole legal guardian, and permitted the child to undergo the gender reassignment surgery without the father's consent. The appellant contends that the right to consent or withhold consent for any medical treatment or intervention for his minor child who is below the age of 18 years and incapable of making an informed decision rests with the father as much as it does with the mother. It is also important to note that the appellants invoke the principle of parens patri conceptually. The parens patri theory is the obligation of the state to protect and take into custody the rights and privileges of its citizens for discharging its obligations. It is primarily used in the juvenile justice cases where the state is given the power to intervene and act for the welfare of the child, and thus replacing the negligent parent, here Mrs. Divya Seth, or the guardian. Thus, the state can not only interfere for minors, but also act as a parent for the disabled and incompetent persons, which grants today's court the power to protect the welfare of minor and persons of unsound mind while respecting the natural rights of parents to decide what is best for their children. Your lordship, this case, this principle itself, which means parent of the nation, was originated in common law, was used by the English chancellery to give power to the crown to administer estates of orphans, which was later adopted in the United States court in the case of Louisiana versus Texas, and hence it found its way into the Indian legal system. The council would like to... Yes, your lordship.
Yes. Does this give the right to the father to slap the mother, to make the mother mentally tortured and leave the matrimonial house? Does this doctrine give him the right? He tortured the wife to such an extent that she had to leave her matrimonial house with the child. So what you're saying, it overrides everything. He has the right to do everything. He can hate, he can slap, he can mentally torture, which results in the wife leaving the house because you are giving a doctrine.
Much obliged, your lordship. Your lordship, to answer your question, the council would like to state that Mr. Sanjay, my client, is not a violent man, your lordship. He has apologized for his actions, your lordship, and he will be willing to take steps to recourse, which he already has taken.
Does that nullify the fact that he slapped? He created a scene in front of his child. He took the child to the psychologist without the wife. So one apology is enough. So once you murder someone, you say sorry, that's enough.
Certainly not, Your Lordship. Certainly not. Your Lordship, it is important to note that this very court has held that in matrimonial discords, which often lead to endless legal battles, it is crucial to understand what an isolated act is and what an act over a course of duration is. Your Lordship, Mr. Sanjay, the reason, Your Lordship, an ugly fight broke out between the defendant, the respondent and the appellant is for the sake of Anubhav. Mr. Sanjay here should not be seen as a husband, but rather in today's court should be perceived as a father who will go to
A
any
father who is hitting the wife is the right person to take custody of a child, according to you? Because the
Your-
child, the High Court has clearly stated he wants to stay with both of them.
Yes, Your Lordship.
But according to you, even though the father is an angry person, a father slaps the wife, throws her out of the house, is good enough without the wife to handle the 11-year-old, now a 13-year-old child.
Your Lordship, to answer your question and Your Lordship, to clarify, Your Lordship, to the bench, Anubhav himself has called his father a person who is a great person, who has been all but nice to him and who's granted all of his wishes, Your Lordship. And he's also shown desire to stay with his father, Your Lordship. And today in today's court, we're deliberating on the position of Mr. Sanjay and the relationship of Mr. Sanjay with his son Anubhav. The ties between Mrs. Divya and Mr. Sanjay have been estranged for a long while, Your Lordship, now. And Your Lordship, Mrs. Divya, she shows double standards here, Your Lordship, especially because she has not taken consent before taking Anubhav to surgery. Not only that, Your Lordship, but she has mentally tortured my client, Your Lordship, calling him homophobic, calling him whatnot, Your Lordship. Anubhav was living in an environment where both of his parents would be in best interest for them to end the relationship, which is what we're contesting in today's court, and which was what was moved in the Lucknow family court as well, Your Lordship. My client states that he can no longer live with Mrs. Divya Seth, who not only disregards his parental authority as a father, but also mentally subjects him to cruelty, calls him homophobic, just so that she could have her own manipulative desires and actually insinuating her own child into being part of a community which she advocates for, Your Lordship. Your Lordship, here it is important to note that Anubhav was a child who came one day home and told his parents that, Mom and Dad, I am suffering from bullying. My peers bully me. And his mother used big words like, since you cannot gel along with your male peers, but you gel well with your female peers, you are a man, you are a woman stuck in a man's body. Insinuating such big words in minds of an 11-year-old child who was trying to channel out, looking for a solution, Your Lordship. All that he was doing is he wanted inclusivity. He wanted to be included. He was being secluded and isolated. His seclusion and isolation was so severe that when his mother came up with one solution, he just stuck to that. He stuck to that solution and he started researching on that. And his research was from where, Your Lordship? From social media, from documentaries of Caitlyn Jenner, who comes and features in a reality TV show. Even if we take the story of Caitlyn Jenner, Your Lordship, he was Bruce Jenner previously. She transformed into a woman, but she's a 66-year-old, Your Lordship. Here we're talking about an 11-year-old child taking inspiration from a 66-year-old. And Caitlyn Jenner herself has undergone all of the mandated procedure, that is all the therapy that she's required, all the psychological analysis. But Mrs. Divya said, even let us say, Your Lordship, for a fact that Anubhav wanted this. Anubhav as an 11-year-old child who cannot decide, Your Lordship, in a tender age, big decisions. But for a matter, let us forget that he has the mental maturity and has decided also, Your Lordship. He should have been given the liberty, the time to have to go through all of these processes so that he's certain in his decision, which Mrs. Divya Seth has not allowed, which is what is the contention of the appellants today in today's court, that Mrs. Divya Seth is not the right guardian for Anubhav, Your Lordship. Your Lordship, proceeding with the rest of my limb of the arguments, if Your Lordship is satisfied with my answer.
Yes, yes.
Much obliged, Your Lordship. Your Lordship, like the counsel stated before, it is the best interest, as my co-counsel also stated, This court time and again has talked about the section 13 and the welfare of the minor child, Your Lordship. Here, welfare of Anubhav has to be seen. And welfare of Anubhav, Your Lordship, is not him being subjected to cruelty in the near future. 11-year-old child, Your Lordship, if today's court decides, Your Lordship, that 11-year-old child can decide whether he can undergo a sex reassignment surgery or any medical procedure without a parental consent, Your Lordship. If such a precedent is set, Your Lordship, then it is only scary, Your Lordship, for the other age groups, Your Lordship. Minors then will start asking for rights to vote, Your Lordship. It will stir an entire new debate on age of majority. Your Lordship, if a minor who is just 11-year-old can take a decision as to which gender he belongs to and is allowed to do so, Your Lordship, then it will only cause turmoil. Your Lordship, there is a study and which is also presented in the written submissions, Your Lordship, that suggests that 90% of these operations have resulted in people regretting after changing their gender. Mr. Sanjay, my client, does not want his son to undergo the forthcoming, the future, in the future, all the turmoil that the transgender community is right now undergoing. They are still treated as second-class citizens, Your Lordship. And Your Lordship, this is a fear of a father and the suicidal tendencies, Your Lordship, after the mental the mental turmoil that Anubhav will be subjected to at a tender age of 11. Your Lordship, 56% of intersex transgender infants have committed suicide because of the factor that they were not included in the society. Your Lordship, the mental maturity, why the age of 18, Your Lordship, is an age of majority? Why did the makers of the Constitution felt like age of 18 was the age of majority? Because there is a mental maturity, there is a scientific backing to it. At an age of 18, when Anubhav has seen enough world, when he has seen his peers, when he's realized and he's certain in his decision, then going ahead with the sex reassignment surgery would make sense. And Mr. Sanjay, my client, was never against his wishes or desires. He simply asked for time. He simply asked his son to utilize every other option out there so that he can realize that there is so much other things that have to come into picture.
Madam, may I come in for a minute?
Certainly, Your Lordship.
What is your topic is item number 2.
Yes, Your Lordship.
Have you come to the main point here? Whether
Yes.
the assignment surgery being done
Yes.
was cruelty within the definition of what? Have you come to that as yet?
Certainly, Your Lordship.
We are on a very short issue here. Whether without the permission, doing a sex assignment, whether that would tantamount to cruelty to give divorce or not. You have to give a very short answer. There's no point in going to something. Please answer that question, please.
Certainly, Your Lordship.
Please.
Certainly, Your Lordship. To answer in a nutshell, Your Lordship, all
Yes.
these legal arguments about lack of informed consent, all of these other issues, Your Lordship, is why the appellant is proving today that there is no welfare of Anubhav here involved. And Your Lordship, as a father of the child, his whole authority as a father was disregarded, Your Lordship. When his partner cannot see that his father has a main role to play, then she has very little regard for him, Your Lordship, which amounts to cruelty, for which the cases of Naveen Kohli versus Neelu Kohli is cited in the written submissions. V. Bhagat versus D. Bhagat is cited, Your Lordship. Also, Your Lordship.
Are the facts same?
Yes, Your Lordship.
Are the facts the same? The facts are same.
Your Lordship, the facts here, in the sense, Your Lordship, talk about cruelty aspect where the wife has inflicted cruelty on the partner, the husband, Your Lordship.
Are you aware of the Indian Penal Code section 498A defines cruelty? Are you
Yes,
aware
Your
of that?
Yes, Your Lordship.
Now the lady could have done that because you slapped her.
Your
So
Lordship.
try and come to something which will be very acceptable to all of us, saying that this is cruelty for these reasons. Don't go to judgment law by itself. You're the future of the country. You're only going by judgment. Nobody reads the act. Try and answer there. What we are trying to impress, at least my impression, I don't know my lords, what my impression is, we are on a very short issue with item number 2. The issue is what would tantamount to cruelty. That part you only answer.
Certainly, Your Lordship. Your Lordship, keeping in mind that Your Lordship wants me to deliberate on just the facts and the statute there and the law there, I will further make my arguments just on those basis and decide, let the court decide on case laws and case
Yes,
proceedings.
yes, absolutely.
Okay, Your Lordship.
Because
Okay,
no
Lord.
facts are the same in all the judgment. No facts are the same in
Certainly.
judgment law.
Certainly, Your Lordship.
Mhm.
Certainly, Your Lordship. The council sees that and the council apologizes and will further not waste the court's time. She will keep her arguments very in a crux and summarize it and state that a slap, just a slap, Your Lordship, by the husband. The principle itself, Your Lordship, here is that the married life should be reviewed as a whole, and a few isolated instances over a period of year will perhaps amount to cruelty. But Your Lordship, one isolated incident in a domestic surrounding, Your Lordship, in a couple's heated argument, Your Lordship, cannot amount to cruelty as stated by Mrs. Divya. But whereas on the other hand, Mr. Sanjay here, Your Lordship, is the father of the child. Mrs. Divya has not only over a course of duration of time, Mrs. Divya has shown nothing but just disrespect towards my client. She has disregarded his fatherly concern and fatherly care, which is what Mr. Sanjay's entire life was around, because he loved Anubhav so much, Your Lordship. If a thorough reading of the Moot proposition would show that the reason why the ugly fight broke out between the couple was because he could not take in the fact that Mrs. Divya Seth was so adamant that she would only listen to her whims and fancies and not regard Anubhav's health, which was going to be subject, which is now, unfortunately, he is open to so many potential risks, Your Lordship. However, Mr. Sanjay wants to step in here and say that if Anubhav's custody is given to Mrs. Divya Seth, then his future is not going to be bright, but only going to see more such potential risks in his life. As far as the question of cruelty goes, Your Lordship, Mr. Sanjay is here subjected to cruelty Your Lordship, just for persuasive value here, the council would like to state the case where not wearing of Mangal Sutra amounted to cruelty, Your Lordship. When the courts had decided that, Your Lordship, the Gujarat High Court, then why not, Your Lordship, disregarding the father here, just not taking him into consideration before making a life-changing decision in his son's matter, not amount to cruelty, Your Lordship. Your Lordship, that is that's the argument in a nutshell, Your Lordship. And to move on to the last limb of my argument, without wasting any court's time, Your Lordship, would be why my client is the right and the right guardian for Anubhav. Mr. Sanjay has emphasized that he is fully qualified and deserving to be declared as the legal guardian because he has done his thorough research, Your Lordship. He wanted to take his son through the step-by-step procedure as advocated by my co-counsel, what the procedure was, and if not followed, what the consequences would be, Your Lordship. However, sadly, Your Lordship, the procedure is done, and even after the procedure being done, Mr. Sanjay is open to the idea of having Anubhav, a she, in his house and raising her the right way, Your Lordship, and not leaving the custody to an unpredictable person like Mrs. Divya, who here has not only done a hasty decision and perhaps a regretful decision in her son's life, which is now irreversible, Your Lordship. If such a parent is allowed to nurture the kid, then the future is only grim. And Your Lordship, it's also important to note that the parental influence a child will have to undergo, and the child's perceptions and feelings towards the father. Here, the father has not had the child's custody for so long. There is already a parental doctrine of parental alienation is already in motion, Your Lordship. With Mr. Sanjay asserting that today's court must listen to his desires, that the court's intention should be to circumvent such ill effects and ensure the child's welfare under the section 13 of the Act of the Hindu Minority Act. The possibility of respondents' effort to get the child to give up her own positive perceptions of the other parent, that is the father, and calling him homophobic, and the father, and to change the agreement with the respondent's viewpoint cannot be ruled out, Your Lordship. This again amounts to cruelty, Your Lordship.
Can I ask you another question?
Certainly, Your Lordship.
Did Sanjay have any avenue by which, through the legal system, he could have stopped this? And you failed to do it as the natural guardian of the child?
Your Lordship, to answer that question, Mr. Sanjay, Your Lordship, was not aware that his son had.
I'm not Mrs. Mr. Sanjay must have been aware because of the Mrs. Sanjay was telling him again and again about the assignment surgery she was thinking of doing. Wouldn't there
Lordship-
be a scope for their father if to stop such an act?
Certainly, Your Lordship. Your Lordship, Mr. Sanjay did not introspect that his wife would take such an extreme step. He knew that she was learned. She knew that he knew. Yeah, he knew that he had selected a learned partner. However, her impulsive decision has now left him in shock, which is why he's moved to the court. Yes, Your Lordship.
Thank
Your
you.
Lordship, finally, Your Lordship, Mr. Sanjay has sufficiently and adequately proven the contention that the appellant's action cannot be considered as acting against the welfare of child. And under the section 7 and 17 of the Guardians and Wards Act again, it is in the best interest and combined vision and greater welfare of Anubhav that this honorable court grants Anubhav's custody to the appellant, Your Lordship. If Your Lordships are satisfied with my submissions, can the council move on to her prayer?
Yes.
Much obliged, Your Lordships. Wherefore, in the lights of the issues raised, arguments advanced, and authorities cited, it is most humbly and respectfully prayed before this Honorable Supreme Court of India that it may be pleased to adjudge and declare that allow this appeal, set aside the judgment in order date 6th of April 2022 of the Honorable Allahabad High Court Lucknow bench, uphold the judgment and decree dated 2nd of March 2021 of the Honorable Family Court Lucknow, and or pass any order or orders as this Honorable Court deems fit and proper in the circumstances of the given case and the interest of justice, equity, fair play, and good conscience. And for this act of kindness and justice, the appellant shall be duty bound and forever pray. Your Lordships, it was an honor arguing before today's bench.
Thank you.
May respondents begin?
Yes, yes.
Yes, yes.
Before beginning, I would like to ensure from your Lordship that I am clearly visible as well as audible.
Yes.
Yes, yes. Thank you.
Much obliged, your Lordship. Your Lordship, may it please the virtual dice.
I couldn't get you.
Your Lordship, may I approach to the virtual dice?
Yes, yes, please.
Much obliged, your Lordship. May it please the court, the council solicits the permission to begin as your Lordship. A very warm greetings to the bench. With the Constitution in my heart, I, along with my co-counsel, is present here to represent respondent in the appeal of Mr. Sanjay Behta versus Mrs. Divya Seth for the purpose of hearing before the Honorable Court. Your Lordship, may I address the bench collectively as your Lordship?
Yes, yes.
Much obliged, your Lordship. Your Lordship, in the disputes today which have aroused in Lucknow, Uttar Pradesh, we were provided with the 3 issues. Out of these 3 issues, I shall deal with first 2 issues and shall take total of 25 minutes of the court's valuable time. In furtherance to which, my co-counsel will be dealing with remaining 1 issue and he shall take total of 14 minutes of the court's valuable time. We shall respectfully reserve 1 minute for Sir rebuttals. Your Lordship, as the appellant has already cited the facts of the case, may the counsel on the behalf of respondent directly move on with his submissions?
Absolutely.
Your Lordship,
Subject to Justice Loth. I
Yes,
think Justice Loth, he can go directly.
you continue your argument in favor of the issues or against the
Yes, 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 yes.
So
The 3 issues,
you
1
may
and
not
3.
put so many questions to the judges.
Yes.
Can you please
Right.
continue your
Rightly
much
said,
obliged,
Bharat.
your Lordship.
Bharat, that's why you are my lord.
and
Yes,
that
lawyers.
questions also are not so relevant.
So relevant here. You just answer what they have said. Just
Yes.
answer that.
Yes.
Much obliged, your Lordship. Very grateful to you. So before moving on with my submission, your Lordship, I would like to make a stand before this honorable court that there was alternative remedy available to appellant to appear before the division bench of the High Court. Though the appellant has directly moved to the Supreme Court by invoking the extraordinary jurisdiction of this court under Article 136 of the Constitution of India. Your Lordship, whether respondent know that when the extraordinary jurisdiction of the Supreme Court is invoked? Let me be very clear at the initial stage of my argument that it is invoked in the extreme, extraordinary, and exceptional circumstances, your Lordship. Your Lordship, it was well-established authority of this court in the case of Ganga Kumar Srivastava versus State of Bihar. Your Lordship, I re-quoted the Ganga Kumar Srivastava versus State of Bihar. My co-counsel can direct the court towards the judgment, please. Co-counsel, please. Your Lordship, in this particular case, which is a case of 2005, the Supreme Court has observed that the Supreme Court must not interfere in the findings of the fact, except in the special and exceptional circumstances when the matter has come under the Article 136 of the Constitution of India 1949. Your Lordship, this court does not work on just assumption of court of law. I just want to know from the respondent where in the Moot proposition this court has granted the special leave to appeal before this honorable court. Your Lordship, in light of this, I would like to refer to the last para, that is 22nd para of the factual matrix. Co-counsel, please. Your Lordship, where it is just written, Your Lordship, that aggrieved by the judgment, an order dated 6th of March 2022, passed by the High Court, Mr. Sanjay filed an appeal before the Honorable Supreme Court on 18th of April 2022. So due to the abuse of process of court and coming under the wrong jurisdiction, Your Lordship, this appeal filed by Mr. Sanjay is required to be rejected outrightly as it lacks maintainability before this honorable court. Your Lordship, if I have satisfied on the jurisdiction part, I would like to move on with my submissions.
You continue.
Much obliged, Your Lordship. Your Lordship, my very first issue pertains to whether a child of tender age of 11 years can take decision upon his own welfare, especially when such decision relates to complex issue of gender identity. The council's submissions in this regard is affirmative, Your Lordship. Your Lordship, I would like to base my entire submission on 4 major grounds. Your Lordship, my first limb of argument is that Anubhav was legally competent to consent to gender change operation. Your Lordship, also secondly, the best interest and welfare principle is applicable in the case of Anubhav. Thirdly, Your Lordship, the mature minor doctrine is applicable here. And lastly, I will contend that Anubhav was well acquainted with the procedure and stages associated with the treatment of gender dysphoria. Your Lordship, coming to my first submission of the first issue, before starting this issue in hand, I would like to...
Mr. Speaker 3, how maturity has been determined?
Much obliged, Your Lordship.
You are inviting the doctrine of maturity. How the maturity has been determined?
Much obliged, Your Lordship.
There is nothing in the pleadings and nothing here.
But Justice Lodh has rightly said, how did you come to this conclusion of maturity? That's what my lord says. You answer that question.
Much obliged, Your Lordship. Your Lordship, I would like to debunk the confusion of the court as the appellant has gravely misguided the court as the consent was only of Anubhav. I completely agree, Your Lordship, the Anubhav has not attained the sufficient maturity, but I would like to bring into the notice of this court that the mother has consented on the behalf of child, being the natural guardian, and child has given just assent to it. Am I satisfied, Your Lordship?
Who is the natural guardian under the law?
Your Lordship, both mother and father is the natural guardian.
No, under the Hindu hierarchy, it's the father. Ordinarily, always the father. Only up to the age of 5, it should be with the mother.
Much obliged, Your Lordship. But after
we are not going into those controversies. You answer Justice Lodh's question. You answer Justice Lodh's question. How could you ascertain maturity? How could you come to a conclusion that the child was matured enough to understand the implications?
Much obliged, Your Lordship.
Yes, please, now go ahead.
Much obliged. Your Lordship, it is most humbly submitted before the Honorable Court that the person who has the capacity and competence can consent to his treatment. Anubhav said to have a capacity as he can understand the necessary information, retain that information, and use it for decision making and communicate the decision by the appropriate means. Your Lordship, the process of informed consent was voluntary and without the coercion in this instant case. I would like to refer to answer.
Mr. Speaker, whether his consent is a lawful consent.
Much obliged, Your Lordship. Rather to say,
come on.
Rather to say it was assent, Your Lordship. There is difference between the consent and assent. The consent can be taken given by the person who has attained the sufficient maturity. But Your Lordship, you are definitely correct on the point that Mr. Anubhav has not attained the maturity, so he definitely cannot consent to that treatment. But he can assent to that particular treatment, as Your Lordship. May I proceed?
So he cannot take decision.
No, Your Lordship.
Consent is not a consent at all.
Yes, yes, Your Lordship.
Go ahead.
But you started with the argument that he has enough maturity to take
To understand the implications.
Yes,
Thank you, my lord.
Okay.
Thank you.
That's all. So, Your Lordship, I would like to cite the Convention for Child Right in this particular case, which has given certain principles in this particular case when we look into. So, Your Lordship, the 4 principles is being provided in Convention of Child Right in this particular case when we come into this particular case is that the principle of non-discrimination, Your Lordship. Secondly, it is also contended that before this honorable court that the principle after the principle of non-discrimination, the best interest of child is being taken into the consideration. And third principle is, Your Lordship, the right to life, survival, and development. And lastly, Your Lordship, the considering the views of the child in decisions that affect them according to their age and maturity. Your Lordship, in the case of National Legal Services Authority versus Union of India, which is a well-established case of 2014, the court has affirmed that the gender identity is an essential part of individual's personality and must be protected. Your Lordship, further,
But whether in this case it is applicable, this principle.
no, Your Lordship.
First,
Why?
go through the facts. Learned senior counsel, Mr. Mukherjee, time and again said that if every case, each and every case depends upon its own facts and merits. So keeping it in mind, you please proceed. So always try to mingle the facts and the law and the judgment, the precedents. And any judgment is not a precedent. The ratio, what is the ratio of
Correct.
of
My lord, I'm grateful to my lord.
Thank you, Mr. Mukherjee.
Really grateful.
Much obliged, Your Lordship. So, Your Lordship, the Committee on the Bioethics of the American Academy of Pediatrics, 1997, citing the Convention of Right of Child, 1989, asserts that, which required to be highlighted at the present nexus of the case, that every child should have the opportunity to grow and develop free from preventable illness or injury. Your Lordship, children under the age of 16 years can only consent or can only assent to the treatment if they are considered competent under the Gillick test of qualifying 5 parameters. In this case, Your Lordship, the 5 parameters is being provided. It is an UK case of 1985, Your Lordship, to bring into the court's consideration. Your Lordship, the very first ground is that
binding on us. Please don't cite something which is not binding on Supreme Court.
Much obliged, Your Lordship. It is entirely discretionary on this court.
Don't cite that then, please. Don't waste the court's time.
Much obliged, Your Lordship. Much obliged, Your Lordship. The council pleads the ignorance. Your Lordship, I would like to draw the attention of the court at para 10 and para 11 of the Moot proposition, where Anubhav has started to feel like a woman, is trapped in his body and showed his willingness to undergo gender reassignment surgery. If my co-counsel can guide the court to para 10 and 11 of the Moot proposition. Your Lordship, the focus is what is significant from the perspective of patient. So, Your Lordship, it is further submitted before this honorable court that there is virtually no Indian case law on the matter of children's ability to consent to hormonal treatment in the context of gender dysphoria. Your Lordship, Article 21 of the Constitution of India, which is gender neutral, gives the right of choice to the individuals, how he wants to be and how he wants to be perceived in the society. So, Your Lordship, this right also comes with the right of self-determination and one's own dignity, because the child has already faced constant bullying in the school, and if the sex change operation has not taken place, Your Lordship, then there was a risk of a child, Your Lordship, as he was side-cornered, ignored, and was a matter of fun in school, there was chances that he might do suicide in this particular case, Your Lordship. So coming on to Your Lordship's query of mature minor doctrine, how the mature minor doctrine is applicable as Your Lordship. Your Lordship, the child can only give assent. The consent can be given by the natural guardian, as Your Lordship has been rightly pointed out by Lordship, that natural guardian is father and father must give the consent to it. So, Your Lordship, the mature minor doctrine recognizes that some minors, yes, Your Lordship. Your Lordship, what I'm trying to contend here is that not all minors are mature, but in some of the special cases, the minor becomes mature before the age they achieve the maturity, Your Lordship. So this doctrine recognizes those minors which are mature enough to evaluate the treatment options and make the decisions. Your Lordship, I would like to humbly cite before this honorable court that Anubhav was well acquainted with the procedure and stages associated with the treatment of gender dysphoria. Your Lordship, it is considered, Your Lordship, it is just considered by the age of 7 years, a child develops competence to distinguish right from wrong and can assent to the treatment or procedure. Your Lordship, a child of age of 7 to 14 years is capable of understanding the medical examination process. So to conclude my first submission, I would like to humbly contend before this honorable court that Anubhav possesses sufficient understanding and adequate intelligence to make an informed consent with the help of his mother. Your Lordship, the current goal of gender affirmation therapy is to help Anubhav and people like him to reach congruence. Your Lordship, by word congruence, what I mean is that the clarity in self-image, self-reflection, and complete self-expression, Your Lordship, so that he can freely live his life and express his gender in the society. Your Lordship, in the case like this, the guardianship, court discretion, and changing circumstances may come into play, and the focus should always be on what serves the best interest and well-being of the child. If I have satisfied on the first issue, Your Lordship, I would like to move on to my next submissions. May I, Your Lordship?
Yes, yes. Proceed.
Much obliged, Your Lordship. Very grateful to Your Lordship. Your Lordship, my second submission pertains to whether actions of Mrs. Divya Seth supporting and taking Anubhav from his gender reassignment surgery without consent of Mr. Sanjay amounts to cruelty and acting against the welfare of the child. The council submission in this regard is negative. Your Lordship, I would like to base my entire submission on 4 limbs. My first limb of argument, Your Lordship, is that the parent have the legal responsibility to make medical decision in the best interest of their child. Secondly, Your Lordship, supporting child's best interest cannot be termed as cruelty. Third, Your Lordship, mother is provided with the status to make rightful decision for child under the Hindu law in the absence of father, as you would say. And lastly, Your Lordship, the three specific criteria that needs to be fulfilled in order for court intervention as parental decision making is justified. Your Lordship, may I move on to my very key submission of this particular issue?
Yes, yes.
Much obliged, Your Lordship. Your Lordship, considering the tussle between the couple, in the views of the High Court, Mrs. Seth was also declared as a legal guardian of Anubhav. If my co-counsel can guide the court at para number 21 of last line of the moot proposition, please. Para 21, last line. Co-counsel, please. Your Lordship, in para 21 last line, it is very clearly said by the High Court that Mrs. Seth was also declared as a legal guardian of Anubhav. So the parent have the legal responsibility. In this case, the mother has the legal responsibility to make medical decision in the best interest of her minor child who lacks decision-making capacity. I completely agree, Your Lordship, but they also have the ethical duty to develop that capacity, Your Lordship. So, but how the person being homophobic, traditional, and orthodox mindset can make such a big decision in the best interest and welfare of the child? Your Lordship, so I would like to plead before this honorable court that the mother is best situated to understand the unique needs of the child. In most of the cases, Your Lordship, a child parents are the person who care the most about their child and know the most about him or her. Your Lordship, being the LGBTQ activist, Mrs. Seth was well aware about the consequences of the procedure, as Your Lordship. As a result, what I would like to substantiate here at this stage is that the mother is better situated than most other to understand the unique needs of the child and to make decisions that are in child's best interest. Your Lordship, also I would like to highlight why mother has taken decision, because this is a point of controversy, that why alone the sole decision was of mother, why father's decision was not taken. So to prove this, I would like to state that at the time of gender reassignment surgery, the couple has started living separately. As the child started living with his mother, therefore the mother was in better position to decide for her child. Your Lordship, in the present nexus of the case, respondent being the supporter of LGBTQ community better knows the associated complications. Your Lordship, therefore, the decision made by Mrs. Seth is very reasonable, because the report says, Your Lordship, I would like to cite a report which says that after puberty, if the person is not getting gender reassigned, then there would be hormonal imbalance which cannot be treated easily, as Your Lordship. It is further submitted before this honorable court, as Your Lordship, that if one cannot adjust in one frame, one cannot say that frame is misshaped. Your Lordship, the respondent has exercised her parental responsibility towards her son, considering the child's future, changing social and cultural norms, Your Lordship. The Article 14 of the Constitution of India, 1949, very clearly says that and prohibits any type of discrimination based on sex and gender. Your Lordship, Mrs. Seth has the right to make decision for gender reassignment of her child, and she did the same. Your Lordship, I am not at all contending that the father does not have the right. The father also have the equal right to decide for his child. But in this particular case, the father was not available under one roof when the sex reassignment therapy has taken place. Your Lordship, next, coming to my next submission, supporting child best interest cannot be termed as cruelty. Your Lordship, in para 16, last line of Moot problem. If my co-counsel can bring the para 16 last line of the Moot proposition at the screen. Your Lordship, in para 16, last line of the Moot proposition, it is clearly stated that on 20th day of January 2020, the sex change operation of Anubhav was successful, and now Anubhav is girl. Your Lordship, let's be little practical and analyze this case by looking into the ground reality, Your Lordship, that the surgery was successful on 20th of January 2020. And the today's date is 30th July 2023. It clearly reflects that it has been 3 years and 6 months past, and there has been no instances where Anubhav has cited that he is undergoing any psychological or mental turmoil. And it is very clear from the facts of the case that Anubhav was facing no physical or psychological challenges after the successful surgery. So it is gravely inappropriate on the appellant side to just assume the fact by themselves. So even if they have alleged that the mental agony of Anubhav after the surgery, they have failed to prove it beyond the reasonable doubt, as in accordance to section 101 of the Indian Evidence Act 1872. Also, Your Lordship, I would like to cite the authority of Anuj Garg versus Hotel Association of India 2008. If my co-counsel can bring this on the screen, Anuj Garg versus Hotel Association of India, which is a case of 2008, Your Lordship, reported at SCC at page number 1. Your Lordship, this court held that the personal autonomy includes the both right of not to be subjected to interference by others, and also, Your Lordship, the positive right of individuals to make decisions about their own life, to express themselves, and to choose what activities they want to take part in. Your Lordship, the self-determination of the gender is an integral part of the personal autonomy and self-expression, and falls within the realm of personal liberty guaranteed under Article 21 of the Constitution of India. Your Lordship, the cases of Navdeep Singh Johar versus Union of India 2018, K.S. Puttuswamy versus Union of India 2017, and Nalsa judgment, which is of 2014, together form the golden triangle of LGBTQ rights in India, much like Article 14, Article 19, and Article 21, which forms the golden triangle for right in the Indian Constitution. Is my Lordship with me?
At least I'm not with you. I'll tell you why.
Yes,
I'll tell you why. I don't know, Justice Loth, he may also say the same thing. You try and understand the judgments, one judgment you gave pertaining to a criminal matter.
Much obliged.
You are given that. Now you come where the gender equality is in relation to workplace employment. How does it affect this case? How is it applicable to the facts of this case? I have not understood that.
Much obliged.
You have to understand, because the problem with y'all is y'all are not capable in the sense y'all don't read the entire judgment, you only go through the head notes. The head notes and the contents of the entire judgments are much different. Please, as you have given me the right of a judge, I must tell you to be good in future. Please go through the entire judgment and find out, because let me tell you, you are making a plea that in 2020, she was successful and now she's a girl, there is no mental agony. Now, what has that got to do with LGBT rights? Tell me this.
Yes, Your Lordship.
You tell me this.
Your
What
Lordship,
has it got to do? Tell me.
Definitely, Your Lordship. I completely understand Your Lordship's concern. Your Lordship, I have cited this case only for the reason because it talks about the personal autonomy of the people who are the LGBT, who are from the LGBT community. Your Lordship, the council plead ignorance on this part, Your Lordship. May I proceed, please?
Please go ahead.
Much obliged, Your Lordship. Your Lordship, moving on to as to medical consultation, as there is a procedure that the medical consultation must be done before sex change operation. So as medical consultation before sex change operation of Anubhav is concerned, I would like to reverently submit before this honorable court that Anubhav is a woman trapped in man's body, was approved by India's best psychologist, Dr. Aditya Sharma. So the condition of consulting the expert is satisfied by the respondent in this particular case. Coming next to, Your Lordship, that informed consent and waiver of the liability clause. The informed consent and waiver of the liability clause, Your Lordship. Your Lordship, no medical professional will do the surgery of the child without the consent of the guardian or without getting signed waiver of the liability form. So, which is well established fact here, Your Lordship. So, I would like to contend before this honorable court by
Was the divorce order passed prior to the consent?
No, Your Lordship.
Then how can you say consent of the guardians? Because she was not declared as a guardian. The father was also a guardian. Then
Your Lordship, in the Geeta Hariharan case, Your Lordship, the thing was that the father was not living under the same roof with the wife. It is the same case, Your Lordship. Here also, when Mrs. Seth got a slap from Mr. Sanjay, the very next day she has left the matrimonial home and moved to the parental home with her child. So afterwards, they have started living separately, and then she has gone through let her child to go through the gender reassignment surgery. So there was unavailability of the father at that particular time.
unavailability, or you did not want to go to him?
Your Lordship, as we can clearly see from the facts of the case that there has been certain disagreement on this particular case. We have to consider the best welfare and best interest of the child in this particular case, as Your Lordship.
Like the mother is the best, the father has no role to play.
No, Your Lordship, I completely, I'm not saying that the father has no role to play. The father definitely has a role to play.
Then,
according to Section 6A, he is the natural guardian. I completely agree.
Then, and tell me one thing, why was it not 15C complied with of the 19 Act?
Much
why wasn't there no counseling of them prior to the Act and after the Act? You see 15C of the Act.
Much obliged, Your Lordship. Your Lordship, what I'm trying to contend here is that it is not necessary that both parent can consent to the medical treatment. The one can also consent to the medical treatment. Hence, all the medical legal formalities has been complied by the respondent before the gender reaffirmation theory surgery of a child Anubhav taken place.
Now you just said Section 6 gives the power to the father. Then how can it be that she could give it on her own? What attempt was made on your part to get this agreement from the father? What stopped you? What stopped you? Is there any communication between the mother and the father pertaining that she needs to go for an assignment surgery? So please give me your consent. Has there been any documentation on that? There's no documentation on that. But you chose to go on your own.
Much obliged, Your Lordship. Your Lordship, I would like to interpret the term absence of father. Your Lordship, the absence of father can be interpreted as a disagreement of the father on the subject matter of the healthcare of the child due to father's own psychological and social constraint. Your Lordship, in this particular case,
I'm sorry to disagree with you. Let's agree to disagree with you.
Much obliged, Your Lordship.
Okay, come on. Sorry to trouble you. Come on.
Much obliged, Your Lordship. Thank you so much for your question, Your Lordship. Your Lordship, right from the case of Geeta Hariharan, which I have already cited. In that case, Your Lordship, the court has held that the Supreme Court only. This court has held that the mother is also a natural guardian of the child along with the father. The court emphasized that the welfare of the child should be the paramount consideration. Your Lordship, also according to Section 13 of the Hindu Minority and Guardianship Act 1956, when the issue comes before the court has to consider the issue from the perspective of the child, as a Lordship. The court also recognized in this case the mother's vital role in child's development and welfare. Your Lordship, if we take into the consideration paragraph 14, last line of the Moot proposition. Your Lordship, the paragraph 14, last line. Co-counsel, please assist the court. So, Your Lordship, if we take this paragraph into the consideration, 14th last line, the quarrel between the couple has grew worse, and in the heat of the moment, Mr. Sanjay slapped Mrs. Divya. But, Your Lordship, it was Mr. Sanjay who slapped Divya, Mrs. Divya said, which is a physical cruelty, and it certainly attracts Section 3 of the Domestic Violence Act 2005 and Section 498A of the Indian Penal Code 1860. It is required to be noted at the present nexus of the case that only after the physical cruelty of Mr. Sanjay, Mrs. Seth has left her matrimonial home with her child, which was the right decision at that point of time. There may be possibility, as Your Lordship, that Mr. Sanjay can inflict some grave injury on the respondent and her child. So acting in the welfare of the child is not an act amounting to cruelty, as Your Lordship, rather than slapping is a physical cruelty in this particular case. So, but rather, Your Lordship, with the changing needs of the societal fabric breaks. So we have to change our mindset. But the concrete homophobic and traditional mindset of Mr. Sanjay towards his child was associated with the career risk of the child, which respondents had overtaken and took the right decision at the right time. Your Lordship, coming to my next submission, which talks that the mother is provided with the status to make a rightful decision for the child under Hindu law. Coming to the 2010 Amendment of Guardians and Wards Act 1890, it has done away with the sole superiority of the father. Your Lordship, the section 19 and 25 of the prior Guardian Act 1890 led to the superiority of the father. I completely agree. Earlier, the superiority was of the father, but after the 2010 amendment, it altered the provision for both of the parent of the child, doing away the sole superiority of the father. Your Lordship, coming to my next submission, this has brought to my next and last submission of this particular issue, that the three specific criteria that needs to be fulfilled in order for court intervention in the parental decision making is justified. Your Lordship, firstly, the medical expert agreed that the treatment is non-experimental and appropriate for the child. Secondly, Your Lordship, the denial of that treatment would result in the deprivation of child's basic need. Thirdly, Your Lordship, the anticipated result. The anticipated result of the treatment gives the child a chance for a normal, healthy growth or a life worth living as evaluated from the child's own perspective. Your Lordship, therefore, it is most humbly submitted before this honorable court that the actions of Mrs. Divya Seth supporting and taking Anubhav for his gender reassignment surgery without the consent of Mr. Sanjay does not amount to act of cruelty and acting against the welfare of the child. Because, Your Lordship, Mrs. Seth is not only a lawyer but also a supporter of LGBTQ community. She is well acquainted with what best suits for her child, considering the child's future and medical health. Your Lordship, hence the certain disagreements which are due to Mr. Sanjay belief system cannot make respondents victim in this case, Your Lordship, and the act of Mrs. Seth cannot become cruel. And for these aforesaid reasons, we urge this court to decide in the favor of respondents. Now, I would like to hand over the floor to my co-counsel who will be dealing with remaining one submissions. Much obliged, Your Lordship. May I please the court.
Thank you, counsel. Your Lordship, may I approach to the virtual dice?
Yes.
Yes.
Much obliged, Your Lordship. A very warm greetings to the bench. As my co-counsel said, I will be dealing with the third issue, that is the last issue. Whether actions of Mr. Sanjay not supporting Anubhav in his decisions to undergo gender reassignment surgery can be termed as acting against the welfare of child. Your Lordship, my submission in this regard before the Honorable Court is that a child has to be experience some major psychological pain in an area of their life that affects practically everything they do, Your Lordship, and every interaction with other human beings. Lordship, consistently over time, if they are confused in gender identity, as in this case, how Anubhav finds himself trapped as a woman in a man's body. Your Lordship, the study shows that the lack of family support to gender dysphoria childs leads to depression, suicidal behavior, and anxiety, Your Lordship. Also, Your Lordship, I want to say that transsexualism is not a new phenomenon, Your Lordship. It has existed for many years and in different cultures, Your Lordship. Your Lordship, in the year 1869, Westphal described a phenomenon he called contrary sexual impifinding, which include some aspects of transsexualism. Also, your lordship, in 1894, Kraft Ebing described a way of dressing according to the opposite sex, which he called paranoid sexual metamorphosis. Your lordship, in this, a boy may dress like a girl, or a girl may dress like a boy. Your lordship. Your lordship, certainly there are various Supreme Court cases in which it was held that the mother has an important role in a child's life, and hence on such basis the mother should be granted the custody of child. If your lordship allow, may I recite some one or two cases that shows that mother can have the custody of child. Your lordship,
Is not the issue here. The
sorry,
issue,
lordship?
third issue is whether actions of Mr. Sanjay not
Much
supporting
obliged.
Anubhav in his
Much obliged.
decision to undergo gender reassignment surgery
Indeed.
can be termed as acting against the
Much
welfare of child. So you must confine to the issue.
Much obliged, your lordship. Your lordship, I'm coming on to that point.
Yes, sir.
Or if you want, I will just say you. I will state my submission now only.
Actually, a rule of argument is that an advocate
Yeah, much
should
obliged.
confine to the issues. He should deliver, he should advance his argument
Indeed, your
in terms
lordship.
of the issue framed by the court with the consent of the lawyers. So,
Indeed.
unnecessary argument when it is made, when it is advanced, then the court may not feel good.
Indeed, your lordship. Actually, when we see, your lordship, in para 3 it can be seen. Let me come to that point, that how this issue is related to against the welfare of the Anubhav. Can I come to that point, your lordship?
Yes, yes, yes.
Come.
Much obliged, your lordship. Let me come to this. Your lordship, in para 3 of the Moot proposition, it can be seen that if Anubhav is good in studies and other co-curricular activities, Anubhav didn't have many friends. He was always made fun of by the boys, your lordship, in the school. Your lordship, even his classmates started to call him gay. Even he didn't mean know the meaning of this words, your lordship. Your lordship. Your lordship, a child cannot leave education, and hormone therapy and counseling, which were prescribed by Dr. Srivastava, was very time-taking process, your lordship. So, your lordship, at this point of time, the father, Mr. Sanjay, was not in accordance with Anubhav, your lordship. He was not he was against the gender reassignment surgery, but your lordship, at that point of time, gender reassignment surgery was in his best interest, your lordship. Sometimes, your lordship, the parent should have the ability to take decisions instantly, your lordship. If I have satisfied your lordship, may I proceed further?
You enter to the issue first.
Much obliged, your lordship.
You read the issue afresh.
Much obliged, your lordship. I have gone through the issue that whether the actions of Mr. Sanjay whether are against the welfare of child. Your lordship, in this regard, I would like to say that although Mr. Sanjay would may have love and affection through for the Anubhav, but your lordship, that doesn't mean his love and affection will always be in the welfare of child, your lordship. Parents may take some wrong decisions in this regards, your lordship, and in this case, your lordship, Mrs. Divya Seth have took instant decision, which was right, of gender reassignment surgery. And your lordship, if we can see that here, Mr. Sanjay also slapped Mrs. Divya Seth, which is an act of cruel, your lordship. Tomorrow may he have slapped his child Anubhav also, or may have done such injurious act which would have harm, which would have a great harm.
So you're supposing everything. Your own basis is supposing something. You're supposing this could have happened. So that is the basis of your saying that she has not done any cruelty to the husband. I think better you come to the point as Justice Lodha has told you, come to Moot question 3, issue number 3, and summarize it, because what is happening is repetitions of what has already been said. Please
Much
keep it
obliged.
small, and please keep it
Indeed.
small and to the point, as Justice
Indeed.
Lodha has been telling you.
Indeed, Your Lordship, pardon. I am just coming to that point by. I'm just coming to that point. May I
Go
proceed,
on.
Your Lordship?
Yes, yes, go on, go on.
Your Lordship, if your child decides that they are ready to tell others about their gender identity, Your Lordship, you can be there as a support system. A parent can be there as a support system. Your Lordship, in this instance, if Mr. Sanjay is against the wishes or wishes and against the situation of Anubhav, then your Lordship, it will harm Anubhav in some other or the other way. Anubhav may get depressed. He may have suicidal thoughts, Your Lordship. Your Lordship, by helping Anubhav affirm his gender, Mr. Sanjay would helping him to discover how to come out and to be their authentic self, Your Lordship. But Sanjay was not at all in the on the urge to do that, Your Lordship. Research shows that gender dysphoria might affect 3.2% of the people assigned female and 4%, 6% of the people who are assigned male at birth. Your Lordship, at this point of time, child goes through major changes, Your Lordship, like Anubhav is going. In addition to separation of both his parents, that additional stress can be heavily on a child dealing with identity issues. So it is extremely important that Mr. Sanjay should be patient and understanding the situation. Your Lordship, I want to go back to the Manu Smritis, in which the quick instant decision taking ability was not there in Dhrishtra, the father of Kaurav. So because he haven't able to took a decision on time, so that because of his
You have still not been able to
decision
answer what Justice Lodh has been asking you for the last 15 minutes.
Indeed, Your Lordship.
Please summarize in 2 minutes and close your arguments. Exactly 2 minutes.
Indeed, Your Lordship. Basically, Your Lordship, my point was that, as we can see that I have said that parent, if in such situations haven't cannot understand or cooperate with child, you then it is the the
Is there any
situation
evidence to that the parent did not cooperate with the child? Is there
Much
any
of-
evidence in the entire moot court problem that the parents did not cooperate with the child?
much
You're
of
saying
Your
whatever
Lordship.
you feel is coming to your mind, you're saying it without there being any evidence to it.
Indeed, Your Lordship.
Not indeed. Show it to me. Don't say indeed. Show that
Much
part.
obliged. Much obliged, Your Lordship. As we can see that Mr. Sanjay slapped Mrs. Divya said it was cruelty.
Slapped is a different part of it. It is with his wife.
But Your Lordship, it was in front of Anubhav, and what Anubhav was
Is it
going
written?
through,
It
we
is in
can't
front of
imagine at
Anubhav?
that point of time, Your Lordship.
Okay, okay, go ahead.
Because
Kindly summarize. And
much
conclude
obliged,
your
Your Lordship.
argument.
Much obliged, Your Lordship. Your Lordship, can I go through some facts about American instances in these cases?
No. You
Want me to
please
summarize?
satisfy the issue.
Okay, Your Lordship.
Issue
Your
number
Lordship. Sorry, Your Lordship.
Issue number 3. Explain, give reasoning.
And keep it short.
Much obliged, Your Lordship. I just want to say, Your Lordship, that when we go through the facts of the case, we see that Anubhav was a child who was in school. Your Lordship, when he told his parents about this situation, his mother quickly come to a decision of going through gender reassignment surgery. Okay, but Your Lordship, Mr. Sanjay waited, and he asked. I am agreeing to that point that he took him to the best psychologist, that is Mr. Srivastava. But Your Lordship, he prescribed a very time-taking method, and This actions, although he was having love, affection and care for him, but these actions were not in welfare of Anubhav, your lordship. The parents are caring for child, that is a different thing, but how they care, are their actions are in welfare of the child? This is the main particular issue here. As we can see, your lordship, that Mr. Sanjay took Anubhav to Srivastava, and he prescribed a very time-taking process, that is going through hormone therapy counseling, which may at least take 2 years,
Whether,
your lordship.
Mr. Counsel, please, in one or two words, you please explain whether, according to you, Mr. Sanjay's action is against the welfare of the child or not.
Yes, your lordship, the actions
Excellent.
were against the welfare of the child, because we can see that he was going through a very time-taking process, and in this between this period, which is the time-taking process, which is about 2 to 3 years, the child may come in depression, he may have suicidal thoughts, he may go through anxiety, your lordship, and now he may.
According to you, is it a case to take a decision about a child's life, affecting the child's life within 1 or 2 months or 3 months or 5 months,
much
or
obliged, your
even a
lordship.
year?
Sorry, your lordship.
Is it the case that a decision should be taken
Indeed.
in 2 or 3 months, or even in a year?
Much obliged, your lordship. I just want to say that some decisions should
Because
be
from
taken.
the very beginning, you please notice that Mrs. Dibba said she
Much
was
obliged.
in support of that changing her gender, changing his gender from the very
Much
beginning.
obliged, your
She took the decision, and
Much
how she took the decision? She was always telling that no, I gave birth her, I gave birth him, so I have the right to take decision, whatever be the consequence.
Much obliged, your lordship.
And not,
Mrs.
you
Divya
are
said.
none. According to her, the father of the child
Indeed.
is none. She is alone to take decision. She has the full authority to take decision, and she
Much obliged, your
she has the right to take decision hurriedly,
Much
without
obliged.
going into without processing
The father.
taking care of all these things, the future, without taking care of husbands.
Much obliged, your lordship. I want to state that mother can take decision, and your lordship. First
Because
of all, I want to clear.
from the very beginning, Mr. Sanjay, he was trying to pacify his wife. Okay, let us take some time. Let us go. Let us consult with some psychiatrist, some specialist. Let us see. Slowly, we should proceed. Okay.
Much obliged, your lordship. I want to state here that both the couples had an ugly fight on 1st September 2019. And in the quarrel, your lordship, she just once she told that she have an exclusive right over Anubhav. Only one single time, your lordship, and that also during the fight, your
No,
lordship.
her subsequent conduct clearly shows that she has always taken decision unilaterally without respecting the opinions of her husband.
Indeed, your lordship. Much obliged, your lordship, but I don't think so. She have disrespected the opinions of Mr. Sanjay. As we can see, first Mr. Sanjay have asked both Anubhav and Mrs. Divya said to move to Dr. Aditya Srivastava. Then they went to him. Then they went to him, your lordship. At that point of time, she haven't uttered a word that why should we go to a psychologist, we will only do gender reassignment surgery. They went, your lordship. So
just a minute. My lord, Justice Lodh.
Yes.
My lord, I have another conference at 6:30. Could I leave with your permission?
Yes.
Grateful.
Yes, thank you. I like to see you soon. Yes.
So if I have satisfied your lordship,
Yes, according to you, Mr. Sanjay's action is against the welfare of the child.
yes, my lordship, and I have even answered the questions which was questioned by the honorable judge, that she again and again used to say that this
Yes, yes.
only Mrs.
You
said.
are saying. Okay. Okay. Next. Next counsel, is there any?
Much
No.
obliged, your lordship. May I move further? May I conclude the argument, your lordship?
Yes, yes.
Your lordship, in conclusion, I just want to say that the simplest and most effective thing during gender dysphoria that a parent can do to help their child with gender dysphoria is to love them, acknowledge them, understand them, and let them know that they are there for them. Your lordship, oftentimes children who struggle with gender dysphoria feel very alone. Your lordship, feel very alone. Your lordship, knowing that their parents are there and want to help them can make all the differences in the world. Your lordship, can make all the differences in the world. For this reason, we urge this court to decide in favor of respondent. Your lordship, the council seek
You
permission
please
to
see para 6 of the problem, the note.
much
Para
obliged, your
6.
lordship.
Para
Much
6 of
obliged.
the that note prepared by uh, by the Moot Court committee.
Yes, yes, I am
Para
there
6.
only.
Para 6.
Yes,
Yes.
his mother, Mrs.
His
said, quickly
mother,
come.
Mrs. Sheth, quickly, the word quickly is very significant here, came to a conclusion that Anubhav was not actually a boy, but he was a woman trapped in a man's body. So
Much
quickly
of
the word,
indeed, your
is it a
lordship.
matter, is it a matter of taking any quick decision, according to you? So complex issues involved. So according to you, is it a matter to take a very quick decision and to come
Much
to
of
a
your
definite
lordship,
conclusion?
but
Yes, he's actually Anubhav is a woman trapped in a man's body. Is it
much
so?
of that.
So many parameters are to be, so many tests, so many things, so many consult. What is the normal
Indeed,
nature of the parents? Suppose a child suffers from
indeed,
any
your lord.
disease or anything else. The parents go from this doctor to that doctor, that doctor to another doctor. So many doctors they consult before, and such a major issue, gender change.
Much
So
obliged,
is
your
it a
lordship.
matter of taking a very quick decision, according to you?
Much obliged, your lordship. But we can see in this paragraph only, first of all, she came to a conclusion that he was a
Quickly,
woman in
the
a man's
word
body.
quickly here, the expression,
Much obliged, your lordship.
expression,
May I explain this para?
the drafters of this problem use the expression quickly.
Much obliged, your lordship.
My question is whether the issue, the problem here, the problem of Anubhav, is
Much
a
obliged,
matter
your
of
lordship.
taking a decision very quickly and come to a conclusion. Yes, he's
Your lordship,
a boy, or he's a girl, or he's a boy, and he's a woman trapped in a man's body.
your lordship, this will
And
be answered by my co-counsel, that is the first speaker.
she even expressed her apathy to consult with other doctors because she thought herself that she has acquired enough expertise in this regard.
Your Lordship, can I answer this particular issue as your Lordship? Just in 30 seconds, your Lordship.
Yes, yes.
Your Lordship, if you see the para 5th of the Moot proposition, which is on the screen, on 1st of August 2019, the parent has asked him about what was wrong with the child. Your Lordship, there was sufficient time given, your Lordship. The minimum time period which must be provided before the gender reassignment therapy is 6 months. So, your Lordship, let's go by the timeline. By the para 5, we can see that on 1st of August 2019, he started avoiding going to school, and Mrs. Seth has quickly come to the decision that she will go gender reassignment surgery. But we have to go to para Your Lordship, this para 16 of the Moot proposition, that is 21/2020, Your Lordship, the sufficient time of 6 months is being given by Your Lordship in this particular case when we go by the timeline as Your Lordship. It means that Mrs. Seth has given the sufficient time so that he can understand about himself, and proper hormonal therapy is being prescribed by doctor of the eminent doctor of Lucknow in this particular case. Then only the gender
Do you
reassignment
think
surgery.
6 months is sufficient for taking a decision in such a matter?
Much obliged, Your
And
Lordship.
without consulting, without further consultations with other doctors.
Your Lordship, may I cite a comprehensive health scheme which is undergoing right from the year of 2020 in the state of Tamil Nadu. Your Lordship, this scheme requires why I cited 6 months, because this is a governmental scheme, and under that scheme, Your Lordship, the age is being provided, and secondly, Your Lordship, the minimum month 6 months is being provided, and an ideal month of 1 year is being provided, Your Lordship. That's why I have cited 6 months, because in the eligibility criteria of this comprehensive health scheme of the Tamil Nadu, the minimum 6 months is required, the cooling period that she have to wait, and she have waited in this particular case as Your Lordship. That's why I have cited the 6 months as Your Lordship. Your Lordship, my co-counsel may proceed with the
Yes.
last submissions, if I've satisfied.
Yes.
Much obliged, Your Lordship. I just want the council seek permission to move on the prayer of relief, Your Lordship.
Yes.
Much obliged, Your Lordship. Wherefore, in the lights of issues raised, arguments advanced, and authorities cited, it is most humbly prayed before this honorable court may be pleased to affirm the orders of the High Court of Allahabad and keep the custody of child to Mrs. Seth.
And to declare, for a child of tender age of 11 years, a mother can take decision upon her son's welfare, especially when such decision relates to complex issues of gender identity.
To adjudge the actions of Mrs. Divya Seth, supporting and taking Anubhav for his gender reassignment surgery without consent of Mr. Sanjay doesn't amount to cruelty or acting against the welfare of child.
And lastly, Your Lordship, to declare the actions of Mr. Sanjay not supporting Anubhav in his decisions to undergo gender reassignment surgery can be termed as against the welfare, acting against the welfare of the child.
And or pass any order, direction, or relief that the Honorable Court may deem fit in the interest of justice, equity, and good conscience. For this act of kindness, the councils, on behalf of the respondent, shall duty bound forever pray.
Is over.
It was absolute honor and pleasure to plead before the Honorable Court, Your Lordship.
Okay, we can conclude. Mr. Mukherjee.
Much obliged, Your Lordship.
Mr. Mukherjee, we can conclude. Can we? Okay.
Your Lordships, are the appellants allowed to give a reply?
Yes. 2 minutes.
Okay, Your Lordship, my co-counsel will be giving the replies.
Your Lordship, with your due permission and with due respect to all the submissions made and due respect to the bench, very quick and very brief.
What is your reply? What is your opinion?
Indeed,
that
yes.
6 months that comprehensive this thing.
Firstly, Your Lordship, since when has time taking for a procedure?
Is there any law of 6 months? Within 6 months, one is to take decision.
Indeed not, Your Lordship. There is no statutory backing. There is no procedural backing to 6 months being an ideal gap for the procedure. Next, Your Lordship, this is a scheme which is persistent in the state of Tamil Nadu. Here, Anubhav, Mr. Sanjay, everyone are residing in the state of they are residing in Lucknow, Your Lordship. It is the Allahabad High Court where the case is taking place. That is a state amendment. How can a Tamil Nadu state scheme be presided in Lucknow, Your Lordship?
Yes.
That being one. Number two being, Lordship, since when has time taking of a procedure become the justification to ignore the procedure, Your Lordship? The procedures are established only keeping in mind the welfare. The procedures are established taking into consideration all the factors. Time-taking process is never a justification for disregarding the procedure, Your Lordship. Moreover, Your Lordship, as I had stated, there is no statutory or no backing as to how 6 months is sufficient time. And as your lordships had rightly pointed out, importance herein is on the word quickly, your lordship. This is mentioned on page number 24 of the written submissions of the appellants, your lordship. The importance is to be given to the word quickly. She decided quickly. There was no sufficient time taken. Therefore, a quick decision taken, being impulsive, is never in the interest and welfare of the child, your lordship. Further, your lordship, lastly, also summarizing it for the convenience of the bench, even though she is a lawyer and an LGBTQ activist, that does not make her an expert, your lordship. The law never recognizes a non-professional to be an expert. She is a professional in law. She is an LGBTQ activist. She is not a professional in the matter of psychiatry, in the matters of psychology of a child. It may be her child, your lordship, but it requires professional guidelines. It requires professional certification, which is why the procedures are established in the first place. Procedures are established to be followed. The time that the procedure will take can never be considered as a justification for disregarding the procedure, your lordship. Therefore, all the acts of the appellant were in true and best welfare of the child, Anubhav, your lordship, as we had also established in our arguments, as your lordships had sufficiently upheld during the proceedings, also your lordships. So that is all the appellant would like to state in their rebuttals, your lordship. Thank you so much.
Yes,
It was
thank you.
It was an
Your,
honor.
your contention is that Mrs. Dibba Seth has taken unilateral decision.
Thank you.
Indeed, yes, your lordship.
Your lordship, may I answer to the question which is being raised by the appellant side as a sir rebuttal?
Yes.
Much obliged, your lordship. I completely
6 months. Where from you have got 6 months?
yes, much obliged, your lordship. Coming to the 6-month procedure, I would like to share my screen, your lordship. Just give me 1 second. Your lordship, if you may peruse to my screen where it's clearly written that National Library of Medicine, your lordship, I would like to come to the submission because it is an governmental site, your lordship, and when we talk about the
is this binding on the entire government, entire India?
No, your lordship, what I'm trying to say is that the Tamil Nadu government, the DPSP of the article of DPSP of the Constitution of India is applicable on the whole country. But I completely
where is it
agree.
written? Show us that where it is written. It's applicable to the whole country. Please show us that part.
No, your lordship, I'm not saying.
Please show us that part. When you are making a submission, please show that part. Then don't make the submission.
And whether it is territory force.
Your lordship, I'm not
Please
saying.
show, otherwise don't speak.
Your
If
lordship, what I'm trying.
Don't speak things which are wrong. Don't make wrong statements before the bench.
Your lordship, I'm not saying that this scheme is applicable in Lucknow, your lordship. I'm completely not saying that.
I'm not saying Lucknow. What I asked you, you said it is applicable all over India. Show us that part. What you just stated.
Your lordship,
Please show that part.
By this, what I mean, your lordship, may I please may your lordship give just 30 seconds to answer?
Take 1 minute, but you're not been able to give us the correct. You're completely misleading the bench.
Your lordship, what I'm trying to say is that the Tamil Nadu government has also.
Again, you are saying Tamil Nadu.
Much obliged. Sorry, your lordship. I will not cite now the Tamil Nadu. I will just like to cite the case, this particular case, your lordship, as regard to 6 months, which is being provided by Mrs. Divya Seth in this particular case. So that also, your lordship, I would like to come to the page where your lordship, the consent is being taken from Mrs. Divya Seth, your lordship, being a guardian, and also the non-liability form of the doctor has also placed into the picture, and all the medico-legal compliances has been made in this particular case before the gender reassignment.
Has it been mentioned in the Moot problem that all medico-legal documents and all forms and everything was duly signed by her, taking consent from the husband?
Much obliged, your lordship.
Anywhere there in the Moot problem, just answer yes or no.
No, your lordship, it is
Keep
not.
Quiet. Keep quiet.
Much obliged, your lordship.
Don't say things which are not in the petition.
Much obliged.
Don't unnecessarily mislead the court.
The council pleads.
That is what you have been doing for so long.
Much obliged, your lordship. The council plead ignorance on that part.
It's not a question of ignorance. You are saying whatever is not there. And what Justice Lodh is asking, you're not answering that.
Your Lordship, what was I was contending is that
You
just
see, Mr. Counsel, you see, in para 10, Anubhav also started to feel that he was a woman trapped in a man's body. He started to watch documentaries about persons who claimed that they were trapped in wrong gender identity. Anubhav was deeply inspired by the story of Kathleen Jenner. So is this the stage of 11 years of old when adolescent period? All these things are to be kept in mind. Learned Speaker 1, Learned Speaker, respondent number 1.
yes, I completely
So
agree
all
with
these things are to be kept in mind that he was going through adolescent period, and some whims and fantasies always influence him. So all these things are to be kept in mind, and wife, the Mrs. Dibba Shet, is found to be very adamant, and also she had been trapped to the fantasies
much obliged, Your
which
Lordship.
her son was experiencing.
Much obliged, Your Lordship. Your Lordship, I completely agree on your point
Yes, yes.
that he has not attained the age of consent,
So-
and I would like to rest the
Okay,
case upon
all
the
are
court.
good, very well. And speaker number 1 is the best one, according to me. I don't know what Mr. Mukherjee's. Mr. Mukherjee,
Absolutely, Your Lordship. I agree with Your Lordship.
and it's a fit case to grant divorce. Samar Ghosh versus Joya Ghosh. Just now I am wondering the fact, because in that case also the Joya Ghosh, perhaps you know, very famous case.
Yes, Your Lordship.
Samar Ghosh and Joya Ghosh, 2004, 2007, I think volume 4 SCC. Yes, volume 4 SCC. So in Joya, the Supreme Court found Joya Ghosh had taken unilateral decision not to have a child. So Supreme Court held that it's a mental cruelty which is bearing upon the mind of the appellant, that is Samar Ghosh, throughout his life.
Correct, Your Lordship.
So it's a in this case also, according to us, it's a unilateral decision taken by Mrs. Dibba Shet to make surgery, to undergo surgery of her son, Anubhav. She ought not to have taken decision so hurriedly. She had to wait.
Correct, Your Lordship.
She had to consult, she had to take more suggestions from experts, from doctors, from psychologists. She had to consult with various special psychiatrists, because they are well-to-do. They may consult with even very good and renowned doctors. So I think the decision has been taken very whimsically, and not and against the real interest of the boy, Anubhav.
We can leave the room, Lordship.
Yes,
And
yes,
we can send the mark sheet to the.
yes.
Yes. Thank you.
Thank you, Your Lordships, for your time.
Thank
It has
you.
been an honor
Much-
arguing before the court.
Thank you.
Much obliged, Your Lordship. It was
Now
an
all are
honor
good very
pleading.
well. All are good very well.
Thank you so much, Your Lordship, for this giving this wonderful opportunity to.
Yes, yes, yes.
Much
You are
obliged,
good.
Your Lordship. Thank you
All
so
are
much.
Thank you.
Yes.
Thank you.
Much obliged, Your Lordship. Thank you so much.
Thank you. Thank you. Thank you.
Thank you, Your Lordship. Much obliged.
My lord, on behalf of the organizing committee, I would like to thank you, my lord, for being here, my lord, judging this competition.
Oh, it's my pleasure.
Thank you, my lord, for giving your precious time to us.
Thank you to give me this opportunity.
Definitely, my lord. I hope this will be a learning experience for all the students who have been able to.
Yes, all are very good. All advanced their arguments very well. They are well prepared, and this is the growing stage.
Yes, my lord, definitely.
All
They are
are brilliant.
understood.
All
They
are
will
all are
be.
brilliant.
Yes, my lord.
Yes. May God bless them all.
Thank you, Your Lordship. Thank you so much.
Thank you. Thank you. Most welcome. Okay. So can I leave?
My lord, the marking
Yes,
will,
Your Lordship. No,
Hmm?
the marking may be mailed or WhatsApp or anything.
Yes.
My lord.
What is the format?
My lord, the same thing has been mailed, my lord. The
Mail.
mark sheet,
Okay.
mark sheet.
Then I will send it tomorrow.
My lord, actually, we have to declare the result, my lord, today at 8
Oh,
a.m.
today
8
itself.
p.m. Yes, my lord.
The mail you through mail you send.
Yes, my lord.
Okay, let me see.
The same mail we have sent the link as well, my lord, over there only.
Those, yes. Link
I don't have any to WhatsApp also.
Huh?
I'm sharing the mark sheet through WhatsApp also to you.
Okay, okay. I have not received any mail.
If my lord wants, we can also write it down. If my lord is comfortable telling it online,
Yes,
that
yes.
suits my lord.
Yes.
Madam, I've just shared you the format over WhatsApp, how the marking schemes are done. So you can, if you can save, then we can
WhatsApp.
write it down.
WhatsApp, okay.
Yes.
What's the